Hi guys, it's Kathy. I hope you can hear me. I hope you're doing well. These Bluetooth earbuds are not working at all. I can hear like every third word. But you guys can just tell me what the videos say. It's not like I've watched them before or anything. I missed you guys. It's been 2 days. That's a long time. My daughter's birthday was this week and we celebrated a lot. So I wasn't able to stream. But anyway, I'm glad we're here now. So I'm going to put the first clip on, though I won't be able to hear it. It's fine. It's about right.
Dylan Haas. Mr. Haas, can you stand up so I can see where you're at? Okay, Mr. Haas, I'm Judge Scott. As you know, I think you've appeared before me before. I won't be the judge in your case moving forward. Mr. Haas, if you don't sit up,
you guys can hear
then
it with no problem,
we're going to have some issues here, sir. These proceedings will be handled by the local judges there in Garfield County. They're also being recorded and live streamed on the internet. Ms. Garcia is our defense lawyer here today. Do you want her to represent you this morning, sir? Mr. Haas, can you hear me?
Yes.
Can you hear it?
Okay, I do appoint Ms. Garcia for this morning's proceedings.
Can you hear anything?
In the event you are released from custody, if you want continued representation by court-appointed counsel, you will need to fill out the public defender application, and if you qualify by their guidelines, they'll be appointed to represent you. Do you understand that? Okay, Ms. Garcia, you waive further reading advisement pursuant to Rule 5?
Judge, I cannot waive further reading and advisement. Mr. Haas did not accept the call.
Okay. Mr. Haas, you have the right to remain silent, to make no statement. Any statement you make may be used against you. You have the right to an attorney. If you cannot afford an attorney, you have the right to request the appointment of the public defender's office. Since you're in custody, you automatically qualify for court-appointed counsel at no cost to you. You can also hire your own attorney to represent you if you choose to do so. Any plea you make must be voluntary, not the result of undue influence or coercion. You have the right to bail. We'll set your bail in a few minutes. You do have a right to a jury trial. You've been charged with the following charges.
This one's a slow burn. The judge has to go through all the legal stuff first.
One count of a restraining order violation, that is a class 1 misdemeanor. One count of harassment as a class 1 misdemeanor. One count of obstructing a peace officer, that's class 2 misdemeanor. One count of resisting arrest, it's class 2 misdemeanor. And one count of unlawful possession of a controlled substance, that's a level 1 drug misdemeanor. The class 1 misdemeanors are punishable by up to 364 days in jail and up to a $1,000 fine plus court costs and surcharges. The class 2 misdemeanors are punishable by up to 120 days in jail and up to a $750 fine plus court costs and surcharges. And the unlawful possession of a controlled substance in the presumptive range is punishable by between 6 months and 18 months in the county jail and a fine between I want to say 500 and 5,000. If you're beating to it, Mr. Hershey, let me know.
Okay.
Yes, fine between $500 and $5,000. There would also be a $1,000 drug offender surcharge. Mr. Haas, do you understand your rights, the charges, and the potential penalties?
I do.
Okay. So at this point, Mr. Hershey, you may proceed.
Thank you, Your Honor. Obviously, I am concerned about the pretrial services report that shows 18 failures to appear, and I believe 15 of those in the last year. I think, Your Honor, a protective order is certainly appropriate here. I understand that the defendant is a transient or homeless and may have some mental health issues on top of that, but the Glenwood Springs PD can't tolerate this kind of behavior, Your Honor. I would ask, he also has other warrants from other communities on the Front Range and a pending felony in your county, Your Honor, in Lake County. So he has a lot going on. I certainly don't feel that a PR bond is appropriate here. I would leave it to your discretion as to that amount. I don't know what sort of resources he has access to, but I certainly think a secured bond is appropriate here given his record the nature of the charges, and more importantly, I guess, his history of failing to appear. Thank you.
Thank you, Ms. Garcia. Ms. Garson. So, Mr. Haas, you've declined to meet with the lawyer this morning. Are you choosing to represent yourself this morning, or would you like me to put you, well, it'd be difficult to do a breakout session at this point because we don't have that facility available to you at this point. That's why we try to schedule those meetings ahead of time. Mr. Haas, is there anything you would like me to know about my posting of your bond without talking about the facts of the case?
Yes, sir. One, I do not have any warrants anywhere. You already checked. I have absolutely no warrants. Two, if I get a PR bond, I can go meet with the lawyer today, like I did last time. I was supposed to schedule. I was supposed to schedule it before my next court date. My next court date isn't until July, August. So I have plenty of time to do that.
Okay, thank you, sir.
And Your Honor, I show warrants in a warrant in 2025-474, and then not one in your case in 25 CR1 in Lake County.
Well, let's just look it up.
You said 25 CR 474?
Right, that's out of...
I'm showing a warrant in Grand County. Well, maybe not. Let me see.
Not in Grand.
It shows up as, but I haven't seen it.
There's not one in Lake.
There. Yeah, that one's closed. Mr. Hershey, say again the number of case you're talking about.
Well, I thought it said on his CPAT, Your Honor, 25 CR 474, but I thought that was a Garfield case, but it says 50-mile assault FTA, 50-mile extradition, Denver, Adams, Jeffco, Arapaho, Boulder, Gilpin, etc. But maybe I guess he doesn't. I don't know where that case is out of, because he also has a case here, 25 CR 122. No, guess not.
Okay, they're almost done with all the lawyer stuff, and then he speaks.
But I don't know if the deputy has any more active holds.
Your Honor, there is no extraditable warrants in our CCIC system.
Okay.
Thank you, sir.
Neither was I.
Yeah, the pretrial service just indicates a non-extraditable warrant. Okay, Ms. Garson, you may go. Mr. Garson, we actually don't need that because he chose not to speak to you. Okay, I do find a protection order is appropriate pursuant to 18-1-1001. The protected party is Gervais Murray. It is ordered, sir, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or a victim of the acts you're charged with committing. Shall stay away from the home of the victim, stay away from any other location the victim is likely to be found. You may not contact either directly or indirectly or communicate with the victim. That means no in-person phone calls, texts, emails. It sounds like this might have been a random encounter, so I don't know that that would necessarily be an issue, but you're prohibited from any contact nonetheless. You may not possess or consume alcoholic beverages or controlled substances without a valid prescription. This order will remain in effect until final disposition of your case or until further order of the court. under the circumstances and with the lengthy criminal history that we're showing, the history of failures to appear, the court does think a secured bond to some extent is appropriate. The court's going to set bond at $2,000 surety or $200 cash. The conditions of your bond, sir: no new law violations will on bond. Notify the court of any changes.
You know, right? They said I have no warrants. None of them. Misdemeanors in the whole one, I'm that high.
Defend your community.
Because you also arresting me. You know that, right? Look at that. This is why I'm mad. This is why I miss court. I don't have that kind of money.
Mr. Haas, your behavior dictates that you are a community safety risk. This was a random
You
type.
say that.
You
I
shall
have a son
notify
at
the
home.
court.
Just keep keeping me from my kid. I have no money, sir.
Okay, I'm going to mute your microphone. You can readdress your bond when you next appear.
Just next time in your mouth, bitch.
Sit down in that blue chair. Don't go anywhere else.
Okay, I'm making a finding that Mr. Haas has exited the advisement room. He has forfeited any further advisement. Additional conditions of his bond: no new, or notify the court of any change.
Monica, thank you. You gave me $10 when he said a bad word. It's like you're paying for swear words, Monica. Thank you so much. Thank you.
To his residential or mailing address, sign the mandatory protection order and comply with its terms. May not consume alcohol or controlled substances without a valid prescription. Will be subject to pretrial supervision in the form of monitored sobriety. He's ordered to report to pretrial services immediately upon his release from custody. No contact with Gervais Murray and otherwise comply with the terms of the protection order. And his next court date will be June the 23rd at 8:30 a.m. in Division 1 of the Garfield County Court.
Thank you, Your Honor. I don't have anything further.
Okay.
Okay. All right. Wait till you hear what happens to this next guy, guys. Wait till you hear what happens to this next guy. I thought I had eye issues. I used to before Canada saved me. But nothing like this next guy.
Reviewed the facts of
Oops.
22 CR 4382, menacing with a gun. And then the facts of this case: menacing with a knife after presenting a ski pass as fare on RTD and threatening the ticket taker. Argument for bond.
Your Honor, so understanding the court's reading of the allegations here, there is a lot to Mr. Garcia Ogwin's circumstances, who he is as a person, and everything that goes into his effect and what was going on. Without admitting to any of the allegations that day, I can let the court know that Mr. Garcia Ogwin does suffer from severe post-traumatic stress disorder as a result of a stabbing to the neck, then multiple counts of attempt murder that were ultimately prosecuted in Adams County. That's right. Mm-hmm. Essentially, the post-traumatic stress disorder does have him heavily medicated a large amount of the time. Because of this, he relies on a strong support system from his family. His mom and sister are both very supportive of him in providing him housing and transportation and the things he needs so that he can deal with the medication, the post-traumatic stress disorder, and everything else he has going on. He does have housing here in Denver. He has an apartment that was it your mom or sister? Sister and mom together purchased to make sure that he was in an environment that was stable, that he wasn't worrying about being out on the streets. With their support, he rarely is in situations where there's going to be a risk to community safety or other events like the allegations in this case could give rise to based on kind of his circumstances. But he, from the resulting post-traumatic stress that occurred after the stabbing, has been a recipient of SSI as his primary source of income. So essentially, he does what he can to rely on his support system to stay stable and to make sure that he's in a place where there's not going to be any incidents or anything else that's happening. Largely, the request for a reduction in bond, specifically defense asking for a personal recognizance bond, also comes from the fact that the court may see in the county court minute notes before this was bound over, he suffered a severe spider bite to his eye that resulted in very obvious issues. An order was issued by that court for
Okay, all right. Let him go. Let him go. That's enough of a crime. That's enough of a punishment. I mean, he got a spider bite to his eye. I wonder if it's just like when they say got a spider bite to the eye, I wonder if it's just like the lid, or right under the eyebrow, or if it's actually the eye. Because no, punishment enough. There's no worse. I mean, you can't go lower than that in jail. I don't think. I think that I don't know what he did because I wasn't paying attention, but he can go free now. He can go home. He's had enough punishment.
medical attention, given the fact that he couldn't see and he'd lost all vision in that eye. It's been represented to me that while he wasn't taken to any sort of hospital, he wasn't provided outside medical treatment. He was provided general care in custody. And while it seems to have resolved a little bit, his vision is still not where it should be. So he is very much trying to find a way to get released from custody so that he can seek outside medical care to make sure that he doesn't have any permanent vision loss, to make sure that he doesn't have any outside complications from whatever's happened to his eye. Right now, he has only had the attention from people within custody.
Ponder. Yo, I would.
Prosecution.
Thank you, Your Honor. The people believe the bond is appropriate as set. Mr. Garcia Holguin has, I believe, 5 prior felonies. He did recently successfully finish probation on one of those, but that probation did end about 4 or 5 days before this offense took place. We do have ongoing concerns with community safety. I'm not aware of any FTAs in this case, but this also does present a little bit of a concern about him returning to court on his own, merely by being able to. It's my understanding that he's currently been banned from all RTD.
All right, well, I'm not going to adjust your bond, sir. Look, it's hard. I can appreciate the issues with mental illness, but you've been dealing with these issues. You've got prior weapons charges. And I just can't put your PTSD or what you're suffering from ahead of the safety of our community. And that ticket taker is just doing his job. Doesn't need to be threatened with a knife by you
I missed you.
for any reason. So if you're not going to maintain your mental health, treatment, it's all right. You can talk to your lawyer. I'm hearing about all the support that you have, but what about on this day? You just don't get to make mistakes with weapons. You don't. So I'm not going to change your bond. I'll set arraignment for June 30th at 8:30.
Your Honor, I understand the court's record. Mr. Garcia Olguin just wants the court to be aware that the previous weapons violation did involve a BB gun, not a firearm.
I read the affidavit. All right. See you on June 30th at 8:30.
He tells you when he gives you the bond.
Reviewed the facts of 22
He
CR.
tells you when he puts you when he puts you on probation. You don't get a second chance. You don't get another bond. You don't get to come back in front of him and get another chance. Now this lady has a slight second chance here. This lady. Slight.
All right, number 81 in the court's docket, 25 CR 364, People versus Mallister. Entries.
Daniel Cohen on behalf of people.
And Maddie Curry for Ms. Mallister, who is appearing virtually with the court's.
Ms. Mallister, can you hear us?
Yes, I can.
All right. There's entirely too much noise there. You're in court. You need to be in a quiet location. You need to not unmute yourself unless we tell you that it's time for you to speak. That's why you were removed from the WebEx.
I apologize.
If we continue having problems, you will not be afforded the opportunity to appear remotely again.
Yes, sir.
What are we doing today?
Your Honor, we are still working towards, and I think we are going to ultimately end up in a restorative justice posture on this case, but I'm having a hard time communicating with the victim about it. He has to be on board before we can go that path. So I will defer to the court and defense's request as far as how to have a little bit more time to finish up that process. But I do think ultimately what we're just looking for is another court setting where we will hopefully have that done. And now I know defense counsel had suggested the possibility that we could perhaps do the screening without actually entering into the agreement. But I will leave that to the people who know this stuff better than I do.
On June 16th or July 21st?
Your Honor, I'm not here on the 16th, so I guess I would prefer the 21st.
And that would be fine with people.
I can't imagine if you can't get a hold of the victim, you can't move forward.
I agree with that. That will be more than enough time.
All right, July 21st, 1:30 for continued arraignment. And where is Ms. Mallister?
I'm here.
Ms. Mallister is home. It's a prior medical issue that was shared with the court. Yes, she's in Colorado. Apologies. Yes, in Denver.
All right, Ms. Mallister, I don't know what's going on, but the next time you appear, I'll allow you to try again remotely, but you need to be in a quiet location.
Yes, sir. I apologize.
Anything else going around? I want you to be prepared for court. We'll see you on July 21st at 1:30.
Thank you.
Yes, sir. Thank you.
Okay, now we're going to do another quick one, but this one's in Colorado. And it's only 2 minutes long and I don't remember what it is. So maybe it's the greatest. I don't know. Whoops.
Cases then?
I'm happy to do one of the other pleas, Judge.
And who's that?
I think I've handed up paperwork just to the side there, Judge.
Christopher Stewart, please. You're Mr. Stewart? Okay. This is 25M 1191. And what is the plea agreement in this case?
Your Honor, Mr. Stewart is pleading guilty to disorderly conduct, offensive gesture as a petty offense for 2 days of jail.
Any credit?
I believe he has 2, but I'm checking Mr. Lentz's math on this. So give me just one moment. Mr. Lentz's math.
Offensive gesture. He got 2 days, two days in jail for that. If I got 2 days in jail for every offensive gesture, oh my God, it would be my life, your life, your life, your life, your life, your life, your life. I am constantly offensively gesturing. Constantly. Yep. Wash the gray right out of the roots because I don't like gray.
Moment. I don't want to make any misrepresentations to anyone.
What do the people believe?
Looking at the arrest report, Judge, I believe he was arrested yesterday.
Okay, so you'd agree with 2 days then?
Correct, Judge.
Okay. And Mr. Stewart, do you understand this plea agreement, sir?
Yes, sir.
So you'd be pleading guilty to disorderly conduct, which is a petty offense. Your sentence would be the time that you've already served, 2 days, court costs, and I'd waive any costs that I could. Do you understand that?
Hey, I don't have no way. I'm homeless. I don't have no way to pay anything.
Well, you'd have to talk to the clerk's office about that and set up a payment plan, or maybe they could waive it, but you'd have to talk to the clerk's office about that when you get out. Do you understand that?
All right.
And do you understand that if you accept this, then you're giving up your right to have a trial or have any other hearings? We're just going to take care of it this way. Do you have any other questions for me about anything?
No.
How do you plead then to disorderly conduct? Guilty or not guilty?
Guilty.
And are there facts to support his guilty plea?
Your Honor, we would be waiving a factual basis.
I'll accept the plea on that basis, enter judgment on that charge, dismissing any remaining charges. Anything else from the people?
No, Judge.
Ms. Frawley?
No, Judge.
Mr. Stewart, anything else you wanted to say, sir? You don't have to, but you can.
No, I'm good.
All right. 2 days jail credit for 2 days served. Court costs, finding of indigency, waiving of any costs possible. Thank you.
I literally cannot work in a restaurant and not have rude gestures all night long. I can't. You would have to tie my hands together or something. I don't, there's no way. There's no way. Because at least every time I turn that corner, no matter where you're sitting, I am giving you the finger, guys. If you're in my restaurant. No, I would never, CJ, don't even say it. I would never do that to food. I would never manipulate food. I would never manipulate their drink. But, yeah. Yep. All right. I'm not about to do it here because I want to go to jail. I call them number one all night long. All right, this woman, guys, it's infuriating. Infuriating. You came here today to be infuriated.
Fenton, which one are you over there?
I'm right here.
Okay, there you go. Can you move? There you go. Perfect. Okay, Ms. Fenton, my name is Judge Scott. I'm the bond hearing officer this weekend. I will not be the judge in your case moving forward. It'll be handled by the local judges there in Garfield County. These proceedings are being recorded. They're also being live streamed on the internet. Ms. Garson is our defense lawyer here today. Did you want her to represent you this morning?
Yes.
Okay, I do appoint Ms. Garson for today's proceedings. Ma'am, if you're released from custody and you want continued representation by court-appointed counsel, you will need to fill out the public defender application. And if you qualify by the state's financial guidelines, they would be appointed to represent you. Do you understand that?
Yes.
Okay. Ms. Garson, do you waive further reading and advisement pursuant to Rule 5?
Yes, Your Honor.
Okay, so what we're going to do is we're going to determine the scope of a protection order that's appropriate, and then we're going to set your bond. I'm going to hear first from Mr. Hershey from the district attorney's office. I do have Michelle Arbany on here as well, so we'll give her the opportunity to speak, and then we will hear from Ms. Garson. So, Mr. Hershey, you may proceed.
Your Honor, I would ask that you hear from Ms. Arbany when I'm done. The defendant, Your Honor, was extradited from the state of Kansas. This case has had a long process of investigation by first law enforcement and then a review by my office and then charging. We actually filed the information here for ID theft. These are very serious allegations, Your Honor, that have really affected this victim's life because using someone else's identification to allegedly buy an expensive car has had a great effect on, as you can imagine, Your Honor, her credit and her life. I understand that the defendant has no history. Her husband has been calling our office. We can't speak to him. I understand she has children. But, Your Honor, I'm going to ask that you either leave bond as set. I was going to ask that you increase it or set it as a cash only, because my concern is if she is leaves the state of Colorado now.
Infuriating. I freaking hate. Infuriating. And this lady just has to deal with it. No one's going to help her. She tells you what she had to do just to get this woman caught. She did. Not no police. No one is going to help her fix this.
We finally found her and got her in custody, that we may not see her again and that she may flee. She has connections to other states. This is not the only fraud that's being investigated, Your Honor. I'm also going to object to any permission to leave the state. We brought her here from Kansas. We want her to stay in Colorado until this matter is resolved. I understand that that's sometimes a harsher position than some DA's offices often take, but I think given the nature of this case, that is the people's request. Thank you. Oh, and a full protection order, Your Honor, for Ms. Aberney. Thank you.
Ms. Aberney, what would you like me to know?
I would like you to know that she reached out and Facebook friend requested me from one of the aliases that I know she uses because it was also on my credit report. I screenshotted that on March 6th. It is not just a car that she has gotten loans with my social security number. There are also multiple pre-screens for CashNet USA, FD personally, and they date. I mean, it's like once a month she's asking for $2,000, and I have all of this paperwork. I can verify it for the judge. She's also taken out email accounts with my name, an AOL account, a Mama Free Girls URLS, a Gmail account. She is deliberately, at this point, stalking and attempting to get as much information as she can to take this as far as she can. I have had a part-time job doing my own investigation. I literally brought the case to the police with all of her information, including her address, her picture. And when I reached out to law enforcement in her hometown of Lewisburg, Kansas, they said their first comment, as I said her name, was, "Oh, we're familiar." So she may not have a record thus far. I've also researched the people that she has aliases under. There's one woman, I believe it's either, I think it's Michelle Cathy, Cathy. You can look at that Facebook page and see that for the last 3 years, there's been nothing except for donate to this, donate to that. Prior to that, there's pictures of another woman who are not Miss Fenton on this Facebook page, personal pictures of the girl and her best friend. So I'm not her only victim. I'm just the one who was determined enough to catch her.
So if I don't get their beer in time, if I put pickles on their burger by accident, if their fries burn, they act like they're going to die, but they're not really going to die. If a nurse just messes up one number in a chart, people die. So yeah, nursing is way worse. Nursing is way, way harder.
Thank you for that information. Give me 1 second, Ms. Garcia.
Your Honor, did the clerk get Miss Aberney's date of birth for the protective order?
Yeah, I do have. I've
I don't want her to say it on the.
No,
She's had enough issues with ID theft, Your Honor. We don't.
I sent it to them through Teams.
Yeah, I don't need her giving out her date of birth.
Oh, she unfortunately got a copy of my credit report, so she knows everything.
Well, let's not make
on
it
the
worse,
credit
Miss
report.
Aberney. Thank
Yeah,
you.
exactly.
Okay. And I want to make sure that the advisement is, since this is an identity theft, it sounds like it's a first set of allegations for that. But I just want to let Ms. Fenton know that in the state of Colorado, if you have an identity theft conviction, and if you have a prior conviction that would be identity theft if committed in Colorado or elsewhere, it is a mandatory sentence to the Department of Corrections if convicted. So I want to make sure that you're clear on that as far as your advisement. Ms. Garcia, you may go ahead, please.
Go to jail.
And Judge, clearly there appears to be information that is not contained within the four corners of the affidavit that is being alleged against Ms. Fenton. What I do have first is we do not object to the no contact order under 18-1001. Ms. Fenton, if there was a CPAT done, and I didn't receive one, but looking at, she does have she had a job until she got arrested, so she was working. She has a residence. She has family and 4 children, a husband, and stability. She has no criminal history that I could find, no prior felony convictions. There was a traffic case that may have shown up, and there was a fail to appear in that one at one point because she was hospitalized. And then that matter was taken care of properly through the courts. She was picked up in Kansas on a warrant. I don't have any information that indicates that she was aware that law enforcement was looking for her or she was ever given the opportunity to turn herself in. But when she was taken into custody, my information is she waived extradition. She did not fight coming to Colorado, that she has shown that she will comply with court orders and wishes to address any allegations. I will also note for the record, she is presumed innocent of these charges, and there are no other charges that either the prosecution has shown or the information contained within the affidavit has shown. So for an individual where there is a presumption of release, there is a presumption of innocence, there are no other bonding factors that indicate that this individual should not be given a PR bond. So I'm asking the court to give her a PR bond. We would defer the request to travel. I think it makes the most sense for the local judge to make that determination, I think, with some parties that have a little more information. Clearly, that will be something that we would be requesting from the defense. But regardless, I advise Ms. Fenton, she would probably need to take up anything like that with a local court when in person.
Forehead tattoos.
And she did indicate that she would be able to stay at a hotel or something here for a couple of days. So I'm asking the court to consider either the PR bond or reduce the cash surety bond to $2,500.
Thank you.
No. Hold on, Hedwig. Hold on.
Thank you.
No. Hold on, Hedwig. She does say one thing in her defense. She does say one thing in her defense soon that explains everything. One sentence before everybody in the room shuts her up.
I do find a protection order is appropriate pursuant to 18-1-1001. The protected party is Michelle Arbany. It is ordered that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall stay away from the home of the victim, stay away from any other location the victim is likely to be found. You may not contact the victim either directly or indirectly, or communicate with the victim either directly or indirectly, including through third parties. That means no direct communication in person, by phone, by email, by text, by WhatsApp, by any form of direct communication. You may also not contact her through Facebook, Instagram, any of those platforms. Any attempts to friend her or to do any of that stuff, as far as the court's concerned, I would consider that to be contact. You're reaching out, asking her to do something for you. That would be a violation of this protection order, which would be punishable by up to 364 days in jail and up to a $1,000 fine. You may not, this order will remain in effect until final disposition of your case, until further order of the court. With regard to bond, the court, the affidavit itself, the court understands what's contained in the affidavit, but obviously the court has also heard from the named victim in this case. The court certainly may consider that in consideration of bond, just as it may consider the arguments of counsel. So the court, this is a property crime. There is no known documented criminal history. However, there has been statements by Miss Arbany about repeated attempts to access her information, her money, to access her, essentially her social media accounts. The court does have significant concerns about that. And just the ongoing attempts to do that. The court does note there's no ties to the state of Colorado. The court thinks the amount of bond is appropriate at $5,000 cash worth.
Make a spider bite her eye. Just make a spider bite her eye.
Surety. I'm not going to make it cash only based upon the absence of documented criminal history and the absence of any known failures to appear. She is here at this point. Additional conditions of your bond: no new law violations while on bond. Notify the court of any change to your residential or mailing address. Sign a waiver of extradition indicating you'll waive formal extradition proceedings if you're arrested in another state and you would agree to be returned to the state of Colorado. She'll sign the mandatory protection order and comply with its terms. You may not leave the state of Colorado without permission of the court. You shall have no contact with Michelle Arbany and otherwise comply with the terms of the protection order. And your next court date is going to be June the 25th at 1:30 in the afternoon in Division 11 of the Garfield County Court. Ms. Arbany, you're certainly welcome to participate in that court proceeding as well. Anything further from the people?
No, thank you, Your Honor.
Anything further, Ms. Garson?
No, Your Honor.
And Ms. Fenton, do you have any questions about what we did here this morning?
No, my Facebook 3 years ago was hacked by somebody.
Okay, Miss Arbany or Miss Fenton, it's probably not in your best interest to say anything at this point. You have the right to remain silent. Anything you say can be used again. And we do have Mr. Hershey here on the WebEx from the District Attorney's Office, so I would encourage you to not comment on the evidence in this case, okay? And Ms. Arbany, do you have any questions about what we did?
So there you have it. Her Facebook was hacked. So she really didn't do anything wrong. Her Facebook was hacked. And we all prejudged her like she was guilty before we even had the trial. Oh, she's guilty. So guilty. Hickory dickory. Oh, Micah already said that. I was late. Micah, that's exactly what I was going to say. Anyway, I love Andrew Dice Clay. I always have. I always will. Watch, he's going to be in the news for some horrible crime now that I said that. I don't know what this next one is. Just mark it as crazy. So let's watch crazy.
August 1st at 1:30 will be your next court date. Thank you.
By the way, this is David Archuleta. So we hear other judges talk about David Archuleta a lot. This case is going in front of David Archuleta, especially when I do bond hearings, which I don't do often, but I'm starting to do more now. That way I don't accidentally get a trial. Do bond hearings. I don't know if he is chief judge. He could be. And I think today we're only in Boulder. I think. So he does a lot of different counties. They zoom in. So I could be wrong. But I think this is just Boulder today and not any other case. But he's very, very strict and he's very hard. And the lawyers tiptoe and respect him big time.
Robert Hunley, 25
One moment. I'll see what's going on. I need a second. You're kidding me. Oh, hold on 1 second. Oh, Jesus. Okay. It's not still doing it now, right? Because I muted it. I mean, I stopped it. Is it still right now? Do you hear a problem or do you hear nothing? Okay. Okay. I don't know what it is.
August 1st at 1:30 will be your next court date. Thank you. Robert Hunley, 25M 1189 and 25M 10. He appears in custody. In the newer case, he's charged with a class 1 drug misdemeanor. And then in the older case, it's an allegation of violation of probation in a domestic violence case. People's position on bond?
Judge, noting that this is a CPAT score of 4 and that the probation complaint in the older case is for not reporting to probation, the people are asking for a $2,500 secured bond.
Okay. And Mr. Lenz?
Yes, Your Honor. Given with this this allegation of a failure to appear, he was representing himself. He did not have counsel and has told me that he was unaware of any conditions that he had to maintain after entering that guilty plea. He's held gainful employment as a master electrician for 20 years. He was supposed to be working today and tomorrow, so he's trying to get out of here as fast as possible. He's building a kitchen. He works for himself. He self-employed, and he has three children, 11-year-old, 9-year-old, and a 4-year-old. He's been here in Colorado since '98. He does have limited criminal history dating back to his last offense of 2003 prior to the most recent ones. He has no previous convictions of domestic violence. He's currently experiencing issues with psoriasis.
All right. Bond will be set on the new case at 100 secured as it was set by the bond commissioners, given the nature of that drug charge, pretrial supervision by probation, report to them within 24 hours of release, and no drugs. And then bond will remain set at 2,500 secured or 250 cash on the post-judgment case. Conditions are report to probation within 24 hours of release, comply with all conditions of probation. Did he want to have his revocation hearing within 14 days on the post-judgment case, Mr. Lenz? Did you talk to him about that?
Your Honor, I don't believe we did talk to him. Mr. Hunley, given that you do have a probation violation matter, you do have a right to have a hearing on that matter in 14 days. We are looking at getting an offer from the district attorney on your cases, and we can resolve it without having a hearing on that if you're interested in waiving that 14-day rule.
I'm just interested in getting back to my kids, whatever it takes to get back.
Yeah, okay. I just want to get back to my kids. Okay. I wonder, though, if this guy is single. This is what I need to know. I'm not going to get my answer, but this is the questions that I have.
My 3 girls. I mean, this is tearing my life apart. I don't know.
So you're willing to waive your right to have a hearing on that post-judgment matter within 14 days, I'm hearing? Is that correct?
If yes.
Okay, so fine, and we'll set it for arraignment in the division. I think he's going to get out, so.
Judge, I'm not inclined to think he's going to be getting out. If
I thought he was going to bang his head there. Did you see that? Oh.
we could.
I heard that it was. Oh, okay, if he's not, he's not. All right.
If we could have the first available PD docket.
Okay.
For Mr. Hunley.
If I can't get out, my wife.
What is it? July 20.
He muted him. He started talking. So we're not watching this guy right now. We're watching another person in jail. I wish I could point him out. I wonder if he's one of these. Could be. I don't know. Yeah, he just muted him.
June 26th at 1:30.
Spencer, do you think that's enough time?
I do. I was just emailing you. I'll see if I can extend you an offer by the end of the day, but no.
Great, thank you.
All right,
Thank you, Judge.
Thank you very much. Robert Keller, 25M 1022, comes on for advisement, setting a bond. He's been charged with misdemeanor harassment, petty offense disorderly. He's a CPAT 2, and they're recommending a secured bond. People's position on bond?
Judge, I'm requesting a $500 secured bond based on the CPAT score, based on his criminal history, which includes a harassment conviction from last year.
All right, Mr. Lenz?
I could take a moment to confer.
Sure.
Yes, Your Honor. We'd like to ask the court for a personal recognizance bond. He's been here since '79. He's been seeing mental health partners for bipolar, ADHD, and a number of mental health concerns, and these are completely voluntary. He's been seeing psychiatric appointments and doctors in Boulder, all on his own. He's trying to seek help. He's attempting to get better. He's tried a variety of medications. Every Tuesday, he meets with doctors and they attempt to find things that work, but nothing has seemed to work so far. But he still has a commitment towards seeking that out. From the beds in here, he has a bad rash and has discomfort, and he does have a friend in the community that he could go and stay with.
Okay, he is a CPAT 2, relatively low level allegations, but he has pretty consistent history, a lot of it quite old, but then some more recent.
Exactly, Micah.
Things. I guess the latest was in 2024, an unsupervised deferred to a menacing. So I'm going to take a chance here and set bond at $2,500 personal recognizance. Continue with any mental health treatment that you might be involved in. Continue to take any medications that are prescribed. No contact with the named victim, and there is now a protection order prohibiting that contact. Do you acknowledge that, Mr. Keller?
Say yes out loud.
Do you acknowledge that you can't have contact with the named victim in this case?
Yes, I can't have contact.
Thank you. The other conditions are no weapons And we'll set this for an arraignment in the division. Say again?
August 1st at 1:30.
August 1st at 1:30. All right, thank you.
And Your Honor, we're ready on Mr. Scoville whenever the court is.
I'm ready. 25M 1178. Matter comes on for setting a bond. He was attempted to be seen yesterday, but would not acknowledge the protection order. Is he prepared to do that now?
Yes, Your Honor, it's my understanding that he's signed.
Okay. Mr. Scoville, do you understand that there is now a protection order in place and that you have to agree to acknowledge the protection order? I'm sorry, I couldn't hear him. What did he say?
He said yes.
Okay. And then people's position on bond?
Judge, it's mine.
Yep. He said, yes, sir. So they totally should believe him. He is not a threat to the victim in any way, shape, or form.
Understanding from talking with Ms. Richardson that the people previously did not object to a PR bond, and we will not be objecting to that today.
That's what I recall as well. So that's what I plan on doing. Did you want to be heard further, Mr. Lenz?
No, Your Honor.
Ought to be set at 2,500 PR, no contact with any victim and no weapons. And we'll set this for arraignment in the division on a public defender day.
August 1st at 1:30.
August 1st at 1:30. Thank you.
We got to be doing something wrong. We have to be doing something wrong. I understand that there is female violence against male partners as well, but we see these court dockets every day in every state, and it's the same thing. Well, there's three things we see every single day, all day long for hours and hours and hours in every single courtroom that we watch. You can't get away from it. DUI and domestic violence, where it's mostly men beating up women. Why? The third thing is men diddling children. And you guys don't ever see that because I don't ever hardly show that. But I have to go through case after case after case of that every day to find the cases that we see. And we have to do something different. Something has to be better because, like, in today's day and age, guys shouldn't just beat up women and children anymore. I know, I understand. There are women that also do it. I'm not saying there aren't. But we see mostly men all day long beating up women. And I'm at my wit's end with it. All right, this next one. Oh, I remember now. All right, this is a short one.
All right, set for status today. What's going on in Arapaho?
Yes, Your Honor. He's set 613 in Arapaho for arraignment. They had a writ issue, so the last date didn't work. We're asking to set out approximately 45 days. It sounds like they anticipate another arraignment. Additionally, we're asking to address bond today.
He's not entitled to a bond, and I can't imagine why I would give him a bond since he just keeps continuing his arraignments.
Remember when the judge said rules, and you didn't really follow the rules exactly, and now you want a bond? Remember that? You're in front of the wrong judge, sir.
I mean, that's not on me.
Well, Your Honor, this is a writ failure. He's only in custody on this case on the no bond hold. He's posted his bond in the other matter. This is the only thing holding him in custody. And he has not, I have no reason to believe based on our conversations that he has been refusing transport or anything like that. He's been ready to go and they're not taking him. He's trying to get all this resolved.
Mm-hmm.
I believe the only complaint other than new law violation is one missed UA and that fines are not completely paid yet.
Yeah, but he's not entitled to a bond, and I'm not giving him a bond. We've got, with his criminal history And this being a weapons charge and the facts of what's alleged in Arapaho, if he goes down on that charge, probation is not appropriate. So. I set it for June 16th. Will that mess up the appearance on the 13th?
I don't think so. I think they'll get him back that quick.
All right, we can set it for June 16th. See what's happening. Okay. He sets it for trial. We can adjust accordingly. If he takes a plea, we'll adjust accordingly.
Understood. All right, 6:16. So
No bond for you. None. Nothing. The next case was stupid. Told you that was quick. I just wanted you, because I always show you this judge giving them a second chance, giving them bonds, but he really doesn't that often. So I was showing you today some of the people who just don't even get to say their case the whole way. The judge is like, no, absolutely not. I love it when so he's hard on the prosecutors, but he's more harsh for the defense attorneys when they say something really stupid. Like they'll get up and they'll say, well, the prosecutor is saying this goes against Rule 504B, and I don't think it does. And the judge will say, well, I do. The defense attorney is like a deer in headlights. Oh, the judge already made up his mind. Anyway, we have one more clip, and we get to hear how the police feel, because all day long the police are arresting these people and they're expecting something to happen to these people, or they just have to go and arrest them again tomorrow and the next day, because they put them in jail and they let them out of jail and then they put them back in jail and they let them out of jail. So we're going to hear how the police feel about the justice system in Denver. You know what? In Colorado. I don't know. I think it's Denver, but I could be wrong.
Who is this? Olirri. Okay, thank you, Mr. Olirri. Okay. Let me get him. We did call Miss Murrow, just so you know, M-U-R-O. Okay, I am.
By the way, security. A few minutes ago, you said how, they make mental health an excuse for criminal activity now, and it's a normal thing, and it is. It is a very normal thing to use mental health as an excuse. However, some people do have serious mental health issues, and it does cause them, to act out. All right. I don't know where this guy falls on that fence, because you get two differing opinions on the mental health issue. But the guy definitely has mental health issues, documented by a doctor, mental health issues. But is he a criminal as well, or was it a mental health episode? I don't know by the end. I'm 100% sure one way at the beginning. I'm 100% sure another way at the middle. And then at the end, I don't know. I wonder if the police made this worse because it was a mental health issue, or if it was just a criminal issue. You guys help me decide.
I'm going to call case number 54 and 55. And that is People versus Mr. Olirri, and we'll have appearances, please.
Josh Nathaniel for the People.
Gabriella Duran on behalf of Mr. Olirri, who appears in custody.
Okay, hello, Mr. Olirri, and thank you for all your patience today. So we are here today for an arraignment in both of his cases. And do we have a resolution, or?
We do. Paperwork was just uploaded with the exception of the elements, which I think are being signed right now.
They were uploaded.
They were uploaded. Okay, I think everything's been uploaded then.
Mr. Olirri. Okay, let me just pull it up here. So the disposition is, let's see here. Let's see, what do we got going on here? Takes so long for this to come up. Okay, I've got case 24 CR 6980. And that case, it looks like it's a misdemeanor plea, correct?
It is.
So that was assault on a peace officer, and we're going to have a misdemeanor plea on that one. Credit for time served. And then the other case is, let me look here.
And Judge, while the court's looking at that, in 24 CR
Yeah.
6980, Officer Garcia, who is the listed victim, is present, would like to address the court.
Okay, great. Is that, yes, okay, great. Wasn't sure who you were, but thank you. Now I understand. Thanks for your patience. Okay, and we have the officer here, and in the 6243 case, there is a plea on that one year deferred judgment.
And there's a record I need to make.
Okay.
So the court will see that earlier today I filed a motion to amend.
I believe you. I haven't seen it yet, but yes, I see it right
It's
here.
been a busy day. The reason I filed the motion to amend is because there was a filing error in that case.
I got you.
So that motion to amend is not done pursuant to the plea.
Because the other one had a serious bodily injury.
It didn't. It was filed that way. And I think the case went to competency court so quickly that, frankly, we failed to do a proper review of the filing document.
That makes sense because I was reading the probable cause statement. I wasn't sure.
It was a mistake. So I would ask the court to amend that before we begin. Does the court want an amended complaint which would reflect that?
Do you think we need?
It's just the only count.
I don't think so. I don't think we do. And so if you agree on case 24 CR 6243, I will grant the people's motion to amend the count 1 to assault in the second degree under subsection 1.
So I can't even tell you how hot it was here yesterday. I don't even have words. So I know a lot of you down south won't understand this, but a lot of you up north will understand completely because you all went through it. A lot of our schools don't have air conditioning. Why would they? Kids are out of school over the summer. And if you're in summer school, hey, that's on you. You should have done good during the year. So, I mean, some of the newer schools, they do have air conditioning, but a lot of them just don't. And we're going to have a heat wave this week that's crazy. It was, yeah, you could chew it. It was so humid today that it was unbelievable. It's not what we get here. I mean, it gets hot during the summer. I mean, it's not always cold up here. It gets hot during the summer, but not like today. Today was a different level of heat. And schools are struggling right now because we do not have air conditioning in the school. I know I went to a Catholic school, so we absolutely didn't have air conditioning ever. And we had those uniforms where you had to wear the sweater. You had to wear the whole uniform. My skirt was wool, and I had to wear it, even no matter how hot it was. So I think they might be closing like schools for a day because of heat. I don't know. We're going to see how this week goes, but that is insane to even think about, that we're closing schools because of heat up here in Pennsylvania. That's not what we signed up for here in Pennsylvania. We signed up for snow. Yeah, we have heat days instead of snow days. We don't really get snow days anymore, but I think the kids here might still be in school because they were talking about closing because of the heat. Yeah, CJ, I don't even know. What heat it was. Carolina Reaper heat, like you walk outside and strangled you immediately. But yeah, that's what's going on in our schools. Soon they'll be out of school and it won't matter, but man.
1C as opposed to 1C.5, which is a serious violation.
Yes, please. Thank you.
We're going to change that one, and I will grant that. So thank you.
Thank you.
Okay, and I'll let you make a record on the other. Okay, so I think I understand what we've got here. Miss.
Wait, what do you mean pretzels? No, chips. Oh, it's chips. What do you mean pretzels? I didn't even know they made pretzels. Oh, it's chips. It's chips the biggest thing they make? Pretzels. We have a country market in Lancaster. And Utz used to have a booth where they would make their chips in the morning. You would get them fresh and hot. And they were so good. I don't think they have that anymore. Now it's just get them from the grocery store.
Sure. Olirri, I do need to give you an advisement before I can accept a resolution of these two cases, okay? I'm going to ask you to please state your name.
Richard Olirri.
And are you the defendant who's charged in these two cases?
Yes.
How old are you?
40.
How far have you gone through school?
9th grade.
Are you thinking clearly today?
Yes.
Are you taking any kind of prescription medicine or pill or drug or anything that would interfere with your ability to understand what's happening today?
No.
Are you suffering from any mental or emotional condition that would make you unable to understand this proceeding?
No.
Okay. And if you'll just bear with me, Mr. Olirri, I'm going to kind of go through each of your cases separately. First of all, let me just make sure I've got the right case. In case 24 CR 6243, it's my understanding that you will be pleading to original count 1, which was assault in the second degree, amended count 1, which is a class 4 felony. There is a 1-year deferred judgment and sentence, right, Mr. Nathaniel?
Yes.
That is proposed on that count, and he's going to tell me more about that, which means that if you do everything, and there's supervised probation with that, is that right, Mr.
Yes.
Nathaniel? If you do everything you're supposed to do on probation for that year period, you'd be able to withdraw your guilty plea on that count, and it would be dismissed, and in this case, that would be all of the charges, so that case would be, you'd be able to close that case, okay? And so that is that case. Your other case, which is case 24 CR 6980. It's my understanding that you'd be pleading to an added count, not in the original charges, count 2, assault in the third degree of class 1 misdemeanor, and would be receiving credit for time served. And I don't know how much time he spent, but Mr. Ram will, I'm sure, tell me how much time he spent in custody. So there would be no additional jail on that sentence. I guess the sentences would run concurrently, probably, to the extent that's the case. Is that your understanding of the agreement in these two cases, Mr. Olirri?
Yes.
Is that how you wish to proceed today?
Yes.
Have you discussed this with your attorney?
Yes.
And are you satisfied with her representation?
Yes.
Okay. So first, I'm going to talk to you about case 24 CR 6980, and I'm going to read you the count. And it states that on or about November 19th, 2024, you, Richard W. Olirri, knowingly and recklessly caused bodily injury to Officer Carlos Garcia. That is assault in the third degree, a class 1 misdemeanor. With respect to that count, what is your plea, guilty or not guilty?
Guilty.
Okay. And now I'm going to go to your other case, which is 24 CR 6243. And I will read you amended count 1 in that case. Let me make sure I've got it here. And that says that on October 14th, 2024, Richard W. Olirri, with intent to prevent Felipe Gallegos, Cervantes, whom the defendant knew or reasonably should have known to be a peace officer, from performing a lawful duty, unlawfully feloniously and intentionally caused bodily injury to Felipe Gallegos Cervantes in violation of Section 18.3203 of the Colorado Revised Statutes. That is assault in the second degree, a Class 4 felony. With respect to that count, what is your plea, guilty or not guilty?
Ask the question.
He's pondering, guys, pondering.
Guilty.
Okay. All right. Before I can accept your plea, I want to make sure you understand your rights and the effect of your plea on those rights. In these cases, you have the right to be represented by an attorney at all stages of a criminal proceeding. And if you're unable to afford an attorney and you qualify for one, we would appoint one for you at no cost to you. We've already done that in these two cases, but in the future that applies as well. You have the right to a speedy and public trial that must be held within 6 months of the date you entered a not guilty plea if you decided to plead not guilty instead. You have the right to have the charges proven against you before you can be convicted of them. And at any trial, you'd be presumed innocent. So you wouldn't have to prove anything. It's the district attorney, the prosecution has to prove all elements of any charge brought against you beyond a reasonable doubt to all 12 jurors, as a jury verdict must be unanimous. At trial, you would have personal rights. You would have the right to testify. You'd have the right to not testify, and you'd get to make the choice as to whether or not you testified. You'd have the right to call witnesses and to present evidence and to ask the court to subpoena witnesses and documents for you. Also, at any trial, you'd have the right to confront any witness who might be called to testify against you and to ask questions of those witnesses. And if you were convicted after a trial, you'd have the right to appeal to a higher court. Do you understand that you have all of those rights?
Yes.
Do you understand that by pleading guilty in these two cases, you'll be giving up those rights?
Yes.
And do you understand there will not be a trial in either one of your cases given your plea?
Yes.
Okay. I want to go through with you briefly your plea paperwork in both of these cases. I've got it here in electronic format. Did you have enough time to go through all those plea agreement papers with Ms. Duran?
And I would just know, he actually went over it with Miss Julia Jones.
I'm sorry, you went through it with Ms. Jones. Did you have enough time to go through everything with Ms. Jones?
Yes.
Okay. And did you feel that you understood the documents?
Yes.
And did she get your question?
Okay, we're almost through this. Hang around. Wait for the police officer to speak, and then you'll make like a firm, you'll judge him guilty or innocent. But then wait for the prosecutor to speak. It's a roller coaster. Get ready.
Answer for you.
Yes.
Okay. And I want to make sure you understand something attached to both of those documents. And what Ms. Jones would have gone through with you is documents that are titled elements, which are the elements of the two charges that you're pleading to today in each of the two cases. By pleading today, you're telling me that you read and understood the elements. Did you have that chance to do that?
Yes.
And I'm sorry, Your Honor, I just want to ask him one question about that because he had a paper copy, but Ms. Jones didn't have the electronic copy of the elemental for the misdemeanor. So I just want to make sure.
Okay.
Because she might have done it with his
Did she go over orally with you the elements, Mr. Olirri?
Yes.
Okay. The elements for the misdemeanor?
Yes.
Okay. All right. And I want to make sure you understand that by pleading, you're telling me you understood the elements. You are admitting you committed the crimes charged. You're giving up the requirement of the district attorney to prove those elements beyond a reasonable doubt. And you're giving up any defense to those charges. Do you understand that?
Yes.
And also, I know even though we have some stipulated proposed sentences here, you are subjecting yourself to the penalties provided by law for the offenses. Do you understand that?
Yes.
Okay. And I want to go through with you just so that I make sure that you understand this. The presumptive sentences in case 24 CR 6243, in which you would be pleading to a class 4 felony, the presumptive sentence is 2 to 6 years in the Department of Corrections If the court were to find certain extraordinary circumstances, you would be sentenced to up to 12 years. There is a 3-year period of mandatory parole and a potential fine of between $2,000 and $500,000. In the misdemeanor case, on a class 1 misdemeanor, the presumptive sentence is up to 364 days in the Denver County Jail, and there is a possible fine of $1,000. Do you understand that?
Yes.
Okay. Now, other than the agreements in the 2 cases that we've talked about, have there been any other promises made to you to get you to enter into a plea?
No.
Are you being forced or pressured to plead guilty in these cases in any way?
No.
Okay. Ms. Duran, does the defense stipulate to or waive the establishment of a factual basis?
We waive.
Okay. And Mr. Olirri, are there any questions that you need me to answer for you about the pleas in your 2 cases?
No.
Okay. So with that, Mr. Olirri, I will accept your pleas and make written findings regarding your pleas and find that your pleas were knowingly, intelligently, and voluntarily entered into. In case 24 CR 6980, judgment of conviction is going to enter in that case on added count 2, and I'm going to dismiss count 1. And then in your other case, which is 24 CR 6243, judgment of conviction will enter on the amended count 1, and that was the only count in the case.
I think that's the one that he has, I believe, has the deferred judgment on.
Oh, I'm sorry. Strike that. There's no judgment of conviction because you have a deferred judgment. So I will strike that. Apologize. Thank you, Mr. Ram. So are we going to go to sentencing?
Yes.
Okay.
There's one important thing I would like to note before Mr. Ann speaks. I think Officer Garcia would like to speak before the court accepts the guilty plea. So the pleas aren't accepted until the sentence enters. And so
that's fair.
And also, as far as the ranges of the initial charges, the court said punishable by 2 to 6 years in prison. They were also probation eligible charges. I explained that to Officer Garcia, but I just want to make sure that we all understand sort of the framework under which we're working.
Right. And even, yes, there's a proposed sentence in this case. But on these sentences, the defendant would be probation eligible or eligible for community corrections or the Department of Corrections. There's not a mandatory prison sentence on those charges. Okay. So do you want to let...
I don't know if Mr. Ann wants to speak first. It's whatever the court wants.
Whatever you...
I just wanted to interrupt just to make sure before we started sentencing.
I usually have the defense speak first, and then I have the prosecution speak, and then I'll have Mr. Olirri speak last if he wants to.
And Your Honor, one other thing, I think there might have been confusion about who was going to upload the plea paperwork, which maybe also was why you're thinking the elemental hadn't been uploaded. And I think it's because I filed that first and then right after the sentencing exhibits. So I have filed the plea paperwork in both cases, and then the prosecution has also filed it, aside from the elemental in the 6098 case.
Okay.
So just to try to avoid
we may have done duplicative work. So.
Yes, it's okay. Okay.
Which is my fault.
That's okay. That's fine. Mr. Randall, and I know you did file some things.
Yes.
Which I have had a chance to at least look at.
Okay, great.
So thank you for that.
Yes, and I apologize. I just wanted to have the paperwork filed first before filing the sentencing exhibits because it just didn't really make sense to do it the other way around. So, and I think, I guess the court is, and I don't know if the court reviewed either of the competency reports at all, but it kind of does, it goes into some detail about his mental illnesses. He does have schizophrenia. He's been diagnosed with that. I obtained a lot of medical records related to that. And he's struggled with that for a while. That's what led him to these cases. He did not have any criminal history whatsoever.
So definitely schizophrenia. And, you know, depending on the severity, he could have episodes, especially if he's not, you know, taking his medication correctly, or worse, you know, drugs and alcohol are involved. So that could cause a mental health episode, not truly a criminal episode. However,
before these two incidents. It's extremely unfortunate and very upsetting situation for everyone to be in. He has a very supportive father, very supportive sister as well. I've personally been in touch with his father, and that will be somebody who will be able to help him in the future. I'm also going to give him a phone call after this hearing, just to update him on the circumstances of his case and how they've resolved. And then if I could just have one moment, I just wanted to look at, sorry, I have too many things open right now. So I just wanted to open my notes. I guess another thing I would mention is that Mr. Olirri has been.
That's so many things I have running in my head right now. Too many things. Close some of these tabs.
Nothing
Hi,
but
Crystal.
extremely polite, gentle, kind, thoughtful, and a respectful human being every single time I've met with him. Again, I'm very upset to see him in this situation. In the second incident, or in the second case, Mr. Olirri did receive multiple fractures about his face. That's the sentencing exhibits that I provided to the court, which included the medical record, which described in detail the several different fractures that Mr. Olirri received, as well as the two mugshots that show his face extremely bloody.
The police broke his face in a couple of different places.
And bruised. One of his eyes swelled from the incident. So I think that's also significant and important. And another form of a punishment that Mr. Olirri has received in these cases. I think I can leave it at that for now. And then if there's anything else I need to add.
Would the court hear from Officer Garcia?
Yes.
Thank you.
And thank you and for your patience today, officer. I know you're probably a very busy man, so thank you.
All right, here we go. It's showtime.
And I've certainly reviewed at least the probable cause statements. That's about most of the information that I've had on the case. So go ahead.
Good afternoon, Your Honor. Thank you for having me.
Yeah, thank you.
I understand that being a police officer carries inherent risk. We accept that danger as part of the job. But with that risk comes a belief, a hope, that the justice system will be fair, impartial, and that justice will be served. Today, I've learned how naive that belief can be. I do not agree with the plea bargain offered to the defendant.
Okay.
The deal is not justice. It's not accountability. It is a failure. The defendant committed second-degree assault on a peace officer. He met every element of that crime under Colorado law, yet as part of his plea agreement, he's receiving a sentence of time served, far less than the statutory minimum DOC sentence for a felony offense, which we've talked about today, of this nature. That is not justice, it is leniency. And it sends the wrong message. It tells violent offenders that even if they assault a police officer, they will face little consequence. This plea deal is not a deterrent, it is an incentive. Further, this decision tells officers like me that our safety is negotiable, that being assaulted in the line of duty is not serious enough to merit real punishment. That is not just a failure to protect officers, it is a failure to protect the public. 7 months ago, I arrested the defendant on a warrant for another assault on a peace officer. It was his father that called us, the one that the defendant mentioned.
So they said that he's had no criminal activity his whole life until now, but that's not true. 7 months ago, he assaulted a peace officer.
Reporting him to let him know where he was so we could arrest him. Surrounded by 7 fellow officers, I was punched in the face without hesitation, no regard, no pause, and that's what makes this individual dangerous. He has already shown a willingness to attack law enforcement. What happens when he encounters a civilian? What happens next time he has a weapon? I believe I was lucky that day. Had he been armed, he would have used it. If he had a gun, I have no doubt he would have shot me. If he had a knife, he would have stabbed me. And now that same individual is being released back into society. I know mental health is often raised in cases like this. The defense mentioned that. I do not dismiss its importance. And I want to be clear. I understand mental health challenges. My own daughter is in a residential treatment center for her own mental health. I live that reality every day. But the defendant had the awareness to hide from police that day. He had the capacity to seek out drugs, find friends, and get high. He had the presence of mind to choose violence. That is not someone detached from reality. He made a deliberate, that is someone making deliberate, dangerous choices. I moved to Denver from New York City. I never imagined that District 4, where I work, would feel more dangerous than New York. Armed carjackings, murders, but more than just violence, I've encountered something else. A justice system that doesn't seem willing to address it, even when Denver has one of the highest violent crime rates in the nation.
I just said I came from New York City and I'm scared of Denver, guys. I'm a police officer. I carry a weapon. I came from New York City and I'm scared, guys. But don't worry. The judge has more to say about that.
I hear it from victims constantly. Why bother pressing charges? Why go through the process if nothing comes out of it? They're not angry at the police. I've been surprised by how supportive the community is of the police. Citizens are angry at the process. They see plea deals like this one and they lose faith. And that loss of faith is the most dangerous thing of all, because when the public stops believing the system works, everything breaks down. The system failed today. It failed to hold a violent individual accountable. It failed to uphold the law. And it failed every officer who puts on this uniform with the belief that justice still means something. The defendant deserves the maximum sentence under the law. He deserves to be punished for what he did, but more importantly, the system must send a message that assaulting a peace officer will not be tolerated, not excused, not negotiated, and certainly not rewarded with leniency. Thank you, Your Honor.
Thank you. Thank you, officer.
Okay. So we heard from the defense attorney that, it was a manic episode. And, it wasn't criminal. It was mental health issues. And this guy is a saint among men. It was just this 2 times, 7 months ago. And now this isn't, normal. This is an outliner. Now we heard from how the police feel about this. Okay. So you might right now already have in your mind whether he's innocent or guilty, whether it's mental health or criminal. But wait, we still have 2 more people. We're going to have the prosecutor give us his 2 cents in all this, and then the judge.
Mr. Nathaniel?
Judge, I certainly appreciate everything that Officer Garcia says. And, I don't have to go out on the streets and put my life at risk. And I don't encounter being assaulted, potentially all the time, like these good folks do. So I can't imagine what it's like to, rightly think that the case isn't, from his perspective, rightly think that the case isn't being taken seriously. So I can't say that I disagree with him. But I can say that as part of my job, I have to treat similarly situated individuals the same. He's not wrong. Years ago, I think this would have been a much different offer and a much different sentence.
So it won't let me type in his crime. It would in Twitch, but not in YouTube. So if you're just tuning in, he punched the cop a couple times in the face when they were trying to arrest him.
But I take into consideration the fact that the defendant has served in excess of 7 months in jail, and that's not nothing. And I take into consideration the fact that, I read his mental health evaluations, and there's mitigation in that. And so it's not nothing. And he's on a deferred judgment. And if he doesn't get control of his life, he's going to go to prison because of the deferred judgment. If he gets out and does what he's done in the past, it gets revoked, and then we would be asking for prison. So, I recognize and I feel bad that I've let Officer Garcia down, but I do think that this is. I mean, it's sort of a blank thing to say this is where we are, but it sort of is where we are with cases like this, and I'm going to treat this case the same as I treat other similarly situated cases, and I recognize the mitigation, and it certainly doesn't mean that it's not aggravated from the perspective of the people who he endangered. So Officer Garcia is right. I apologize for what that's worth. I think the court can accept the plea or not, but it is what I think was appropriate in this case.
Okay, I appreciate that record. Thank you. Is there restitution, Mr. Nathaniel?
There's not. Thank you for asking.
Okay, all right. Mr. Olirri, is there anything that you'd like to say?
Your Honor, if I could speak first before if he decides. I just also wanted to share, and I think the court is aware of this, that Mr. Nathaniel is extremely strict with these types of cases. He takes them very, very seriously. From working with him, I've noticed that these are the cases that he cares about. I mean, he cares about all of the cases, but he in particular is concerned and cares about these cases.
The defense attorney is jumping to the prosecution's aid. She's a knight in shining armor.
And so if he finds that the offers in the cases were appropriate, I don't think that the court should question that at all, given how he is with these types of cases to begin with. In addition, I just wanted to explain a little bit about the incident, and this is the one where he received the fractures. So he was in the back of a shed that had a lot of things in the shed, including things like shovels, other types of garden tools. The officers opened the shed door. They were calling to him. He was crouched down. He got up. One of the officers, I remember he said something like, are you chill? Are you being chill? Whatever. And he said, yes. He was basically talking to them the entire time. He started walking out, and then he had his hands in his pockets. The officers asked him to take his hands out of his pockets. He started to do that. He had one hand out of his pocket, starting to get the other hand out of the pocket. And then I think that was just still too much for the officers as far as a safety risk goes. And then the punch happened, and then they took Mr. Olirri to the ground. And so I think it's helpful to provide that context to the court. I think it also, he could have had the opportunity to there were plenty of things that he could have grabbed in that shed to use as a weapon or to arm himself. He did not do that. And so I just wanted to share that with the court as well. In addition, as Mr. Nathaniel alluded to, he does have 224 days of pre-sentence confinement credit. So he's spent.
So that's something else too. He's already been in jail 7 months. So, I mean, he's not getting off with nothing. Even if nothing happens from here.
A very significant amount of time in custody. And then if I can just ask Mr. Olirri if he would like to.
Okay.
Thank you.
Okay. Is there anything that you'd like to say? Mr. Olirri, you don't have to, but if you'd like to, I'd like to give you a chance. You don't want to?
That's all. The thank you.
Okay. All right.
Thank you.
Okay. Well, thank you. And thank you, officer, for coming here. I can't imagine what it's like to put yourself out there like that every day. I know how dangerous it is. I do. I'm from New York, and I feel safer in New York City than I do in this city. So I completely understand where you're coming from, and your service, and how risky it is to be out there every day. And thank you. And I'm sorry that you feel that the justice system has failed you. I understand that. And there's many things that go into why plea agreements happen. And I'm sure you can imagine that. And I'm just sorry that this has left you feeling that that you've had a failure of the justice system. I am sorry. I did obviously read the file in this case, and Mr. Olirri, I think he's just come up here from having been in our competency court for some time. And I don't excuse the conduct, but there are some mitigating circumstances here that I think, I don't think Mr. Nathaniel would have offered that plea agreement lightly. And so I do think, again, I too have to consider similarly situated individuals and fairness in sentencing. And I think this is an appropriate disposition based on everything I've reviewed in these files. And Mr. Olirri, all I can say is that on that deferred judgment, which really is a gift of a sentence, if you don't do what they ask you to do, there isn't going to be more probation in this courtroom on that type of a sentence, on that type of charge for that conduct. I think you know that. And so what I'm going to do then in case 24 CR 6980, and I just want to make sure I have that is the one where it's credit for time served, right?
I believe so. Let's see, hold on.
And you said it's 224 days he's served in the jail.
Correct.
Yeah. So on that count, the way that we would have to do that, because it is a felony count, I would sentence Mr.
I think
Olirri.
that's the misdemeanor.
That's the misdemeanor. I apologize. Yeah, you could. Yeah, that's the misdemeanor. And on added count 2, Mr. Olirri, on case 24 CR 6980, I'm going to sentence you to 224 days in the Denver County Jail with 224 days of pre-sentence confinement credit, and your sentence on that case will be completed. In case 24 CR 6243, on count 1, amended count 1, there's a 1-year deferred judgment and sentence. The return date on that deferred judgment is June 11th, 2026. That's 1 year from today, Mr. Olirri. What that means is that's technically a return date back in the court to make sure you've done everything you needed to do. But what usually happens is if you've been fully compliant with probation, they will let us know in advance, and we'll just issue a written order that discharges that sentence and closes out the file. But unless until you hear that that's happened, you do need to appear in court June 11th, 2026 at 8:30. It's a year is a long time away. If you have questions, you can call our courtroom 5A, or talk to your probation officer, and they'll be able to assist you. There is supervised probation as a condition of that deferred judgment and sentence, and the normal terms and conditions of probation will be incorporated into your sentence and anything else that they identify at the time of your intake. There's no restitution. Okay. Mr. Olirri, I am going to waivable fees and costs for you in light of your indigency. But in case 24 CR 6980, I am going to impose the Victims Assistance Fund and the Victims Compensation Fund on that count, because I think that is important in that kind of a case, that there's some recognition of impact to victims. And again, in case 24 CR 6243, I will waive all waivable fees and costs. And so, Mr. Olirri, I don't know when you're going to get out of custody, but I'm going to ask that, I would assume you get out today, but I'm going to ask that you report to probation no later than Monday, because I don't know exactly what time you'll get out. This coming Monday, before the close of business, you must report, or there will be a warrant for your arrest for failure to report. They will have you fill out some paperwork, and they'll set you up for a longer intake appointment. Okay. And Ms. Duran will give you a card. Do you know where probation is? It's if from the front of this building, it's right across Colfax and up about a block to the east. There's a big building. It looks like it's up on legs. You can't miss it. It's a big concrete building, and she'll give you a card with the address, okay? So with that, Mr. Olirri, I'm going to wish you hopefully success. Please don't squander that deferred judgment, because if you don't do what you need to do, a felony conviction will enter on that count. And that's why I read you what the presumptive sentence is. We won't be coming back to another probationary sentence. Okay? All right. All right. Thank you.
Thank you.
And thank you again, officer.
Sorry about your luck, officer. So I can tell you, I know people from Australia, UK, other countries. I know in the media, when there's protests, it looks like there's rioting all over America. I've never been in a riot. I've never been anywhere where there was a riot ever. I remember the riots with Rodney King in LA. There was none here ever. Even when it was that bad, those were big riots back then. But I mean, yeah, they happen, but it's not everywhere in America. Not everybody in America riots. We do actually peaceful protests. Now the military are arresting citizens for that, but that's besides the point. I bet he was. All right. Some of you are going to meet me in OJ. The rest of you can go to have a good day. I thought you thought I was going to say something else. No, I'm going to OJ now. And I shall see most of you soon. Thank you so much for coming out, guys. I really, really appreciate it. Have a great day.
Electric light, late night when the world sleeps. She's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Right, even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue, in her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a way there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray,